Good morning, good afternoon, good evening. This is Meg Strickler, and I'm based in Atlanta, and I'm thrilled to bring you this webinar from iTech Law, Confusion Reigns, Transnational Cybersecurity Compliance. It is most definitely a confusing topic, and we are thrilled to bring you an excellent panel this morning. I say this morning because I am based in Atlanta. And what I wanted to say at the beginning, at the onset, is iTech Law is an amazing group of people. And if this is your first webinar, you're going to be absolutely thrilled to see how much you're going to learn in just 1 hour. I really urge you to become more involved in iTech Law. Please look at the chat. You can always reach me. My name is Meg Strickler. Just Google me and you can reach me. I'm the chair of the iTech Law Cybercrime Committee. You can become involved by doing that, but also you can become more involved about joining the committee by looking at the link right now in the chat. I would love for you to become more involved. We can do more webinars just like this one. Also, we have many, many conferences coming up. At the end of this webinar, you'll learn about that. So without further ado, here's Jennifer Davidson, and she is going to moderate this excellent webinar. Thank you.
Thank you, Meg. As Meg said, my name is Jennifer Davidson. I am a technology, privacy, and cybersecurity lawyer at Deeth Williams Wall in Toronto. I am going to set the table briefly and then jump right in as we have something of an action-packed hour for you today. So joining us this morning or afternoon or evening, depending where you're joining us from, we've got data protection lawyers from around the globe, or at least as many as we can fit on the screen. I will not read their full bios to you because you can see it on the iTech Law page, but I will briefly introduce each. First up, we've got Fran Fairclough. Fran is a data privacy and cybersecurity lawyer from Ropes & Gray in the US. In her practice, Fran advises clients on data privacy, cybersecurity, and information law relating to data breaches, ransomware, and internet governance. She regularly counsels clients on compliance with federal, state, and foreign privacy and security requirements. And next up, we have Stuart Davey from Pinsent Masons in the UK. Stuart advises on cross-border data breaches and cyber incidents. He helps organizations ensure compliance with their security and reporting obligations under relevant data protection legislation and regulation. He also advises clients with the increasing challenges of data and cyber-related litigation. Then we have Tino Talpak from Dora's IT and data protection legal practice in Austria. Nino's practice focuses on data protection and IT security law. Nino is the coordinator of Dora's data protection unit, as well as acting as an external data protection officer for select clients. And last but not least, we've got Thomas Valinet, who is a technology, media, and telecommunications lawyer at Trilegal in India. Thomas routinely advises on regulatory, contractual, policy, and government affairs and litigation mandates. So today we plan to start off with a brief overview of compliance regimes in each of the represented jurisdictions. Then we're going to move into a discussion on transnational cybersecurity considerations, and we'll save time at the end for questions from the audience. If you have questions, please use the Q&A function, and I will do my best to ensure that those questions are answered during the Q&A period. Also, the team here today has prepared a compliance overview handout, which Hazel has kindly volunteered to share via a link in the chat and post on the page for this discussion. The handout is, well, thank you very much, Hazel, very timely. This handout is meant to provide an overview of compliance obligations within the jurisdictions represented, but does come to you with a caveat that this is a rapidly evolving area and legislative changes come into effect almost daily. So without further ado, I'd like to ask our speakers to start off with a brief jurisdictional overview of cybersecurity compliance requirements within their jurisdiction. And Stuart, I think we're going to start off with you.
Thanks so much, Jennifer, and hello, everybody. Delighted to be here. As Jennifer mentioned at the outset, I'm based in London, so I'm going to kick off with a UK-focused approach. And I'm going to distinguish between, I think, broadly two themes, one of which is data protection and privacy-related considerations, and the other being other things to think about from a compliance perspective. And that latter piece, I think, is important because in the UK, and Nina may well develop this from an EU perspective, we're certainly moving towards a more fragmented approach to compliance obligations. So we're seeing more different bits of regulation that organisations need to consider when it comes to responding to a cyber incident. But let's pick up the sort of the starting point, perhaps, which is data protection and privacy implications. So in the UK, we post-Brexit have our own version of the GDPR, known as the UK GDPR, which in all accounts is pretty much identical. And sort of the things to think about when it comes to the security obligations are that they are one of 6 or 7 key principles of the GDPR. So the other 6 are lawfulness, fairness and transparency, purpose limitation, data minimization, accuracy, storage limitation, and accountability. And I'm not going to dwell on those other 6, but they are all important to flag. And one of the reasons for that is that when we report breaches to the regulator, so in the UK, the Information Commissioner's Office, although that incident may be related to a particular breach, quite often the questions that follow may expand out, have a land and expand approach of asking questions about the organisation's wider compliance. And so considering security related obligations in the context of wider data protection and compliance is important. So I think that's my key first takeaway, which is that obviously having a security related compliance is very important, but also wider data and privacy compliance is equally important. Focusing quickly on the security obligation, the main obligation in the UK GDPR, as it is in the EU GDPR, is set out in Article 32, which requires both data controllers, the owners of the data, and their data processors, those who are processing data on behalf of the data controllers, to have in place appropriate technical organizational measures to ensure the security of the data. And they're entitled to do that, taking into account things like the state of the art, costs of implementation, and the nature of the processing obligations. So it's a very principles-based obligation. We don't have a set strict list of things that organizations need to do to ensure security compliance. And that can cause difficulties because we often get that question from our clients of, well, what does that mean? What does appropriate technical organizational measures mean in practice? And there is some guidance. So the main guidance that we have in the UK is actually found in one of the monetary penalty notices issued by the ICO against a law firm known as Tucker Solicitors, who had a ransomware incident. And it defines the kind of things that the ICO considers should be taken into account when assessing things like state of the art. And broadly, they point to the ICO's guidance, standards like ISO 27001, NIST framework, and so on. So there's lots of material organizations need to be considering in the context of their processing to ensure they have the appropriate level of security. And again, to reiterate, that's something that controllers need to be having in place, as well as the data processors. And there's further obligations on the controllers to ensure that security measures are flowed down to in the contracts of those providing services. Brief whistle-stop tour of the privacy and data protection implications, just very quickly moving on to the other things that are out there. And again, this is an evolving, rapidly evolving landscape. There's several bits of legislation in the UK that impose security-related obligations on organisations. So, for example, organisations in the critical national infrastructure are covered by the Network and Information Systems regulations. Organisations, telecommunications providers are covered by Telecommunications Security Act and Telecommunications Act obligations about security, and so on. So different types of organisations have additional layers of security obligations imposed upon them. And then in addition to that, a lot of the regulators have in place guidance or obligations within their own regulatory frameworks, whether that ranges from solicitors through to financial services, banks, and so on. So a broad spectrum, which can make it hard for organizations to think about their compliance and make it difficult for those responding to an incident to map out what they need to do in a short period of time. That's my overview, Jennifer.
Well, thank you. I'm trying to take notes as I'm in here. I should probably do that after, I think. Nino, would you like to take it over from here?
Yes, of course. So basically, if I'm listening to what you've said, Stuart, it's nearly the same regarding GDPR. So if we look at personal data, if you have a data breach, then usually any kind of cyber attack involves a data breach. First of all, so we do have also the 72 hours. You need to notify the data protection authority. You need to be prepared. That's the legal point of view. What I would like to add is, in addition, in practice, you often have a high risk implied for the data subject. So you also need to additionally inform the data subject himself. This might be your own employee, this might be former employees, this might be job applicants, and of course your customers, your business partners. And that's where we also usually in practice step in from a strategic point of view. So we also have, like you mentioned, network and information security, additional notification duties, separate notification duties for banks, credit institutions, telecom providers. So it's a lot of information that needs to be prepared in different models within the first 48 to 72 hours to be properly prepared and then presented to the authority, who then have in parallel different notifications and different proceedings in the end. And at the same point in time, what we see in practice is, especially if it is a cross-border incident, there is a different models, of course. So we are far away from full harmonization, even within Europe and the European Union. So you have different models, first of all, and then you also have a different focus and practical experiences in practice. So if we receive, a prepared notification for a specific cyber attack from a German colleague, we need to have to change something in the wording regarding maybe the specific measures that have been implemented afterwards. And if we receive a French model or a model from Italy, there are other things that we need to change. It's really not only a wording perspective, it's also about the focus and strategic advice. And if you think of the cyber attack itself, let's take ransomware, for example, then in addition, it comes, of course, with the reputational risk that you also need to not only steer the information towards the authorities, but also internally, inform your employees, have models in place, have a communication channel in place, even a backup of that, in order to be even able to inform your employees, like something happened, what can be revealed at that point in time, what should be revealed afterwards. It always needs to be aligned with what you have told the authority. You may need to have an update or any kind of information on your website because your website's down or your social media account is still out there and is still active. So you also need to be prepared from a strategic point of view. And also, as you mentioned at the beginning, beside all these notification and primarily GDPR focused issues that might come across, you also have usually one of the first questions like, do we have a cyber security insurance? Will they pay for that? Will they pay for all the external forensics, lawyers, communication crisis teams that we have involved? And the second point is, of course, always the question, is it legally allowed to pay the ransom? So this is what we also deal a lot of in Austria. And just to be rather clear on that, from a purely legal perspective, there are some good arguments to being able to pay a ransom, to legally, validly pay a ransom. Of course, there are many questions to be answered along the road to come to that conclusion, but it is or might be possible, and there might even be some insurance coverage on that. But I also learned, especially in cross-border, that this is the question that is differently answered across Europe.
Thanks, Nino. And that's a subject we're going to get into a little bit more, the legality of payment of ransom. But we'll do that in the discussion period. Right now, I'd like to pass it over to Thomas.
Hi, folks. I think the basics in India aren't too different. There's essentially a few surface areas of impact that you need to consider in any cybersecurity incident, and even when, for that matter, when you're thinking of structuring cybersecurity compliance. One is, of course, you have your regulators like Stuart and Nino mentioned. There are various regulators in India that each seek to want to have their own turf. For instance, the financial sector regulators are very, very active on cybersecurity, insurance, securities, banking. We have a whole range of, in telecom, for instance, is another regulator that's really active on cybersecurity. So we have a whole range of regulators that are active. We have And this is a recent phenomenon of few omnibus legislations that deal, or other directions that deal with cybersecurity compliance and breach reporting. The first is, of course, what we call as in India as the CERT-In. The CERT-In has issued a set of directions. It's the regulator that deals with cybersecurity matters in India. It prescribes a certain set of cybersecurity compliances, for instance, log-keeping requirements, what your servers must comply with, for instance, what time clocks it must be syncing with, what are the various identity requirements the servers must comply with, a whole range of cybersecurity compliances on that. And more crucially, and I think, that as a matter of interest for the participants here, it has a 6-hour reporting window. Compared to, I guess, what we've seen elsewhere in the world, which is, I think, 48 to 72. We have a 6-hour window here in India under the omnibus law. We also have a new privacy law that requires you to report personal data breaches separately to the Data Protection Board, which is yet to be set up in India. It's going to be set up over the next couple of months, is what we hear. This reporting, however, we understand is going to be, maybe a little bit, we may have a little bit more time to report here, but the kind of downside here is you have to report not just to the board, but also to every single, person that's affected by a particular data breach, right? So that's the other omnibus kind of legislation that applies. The third surface area that I think I want to sort of speak about is your relationships with your vendors and your customers. There's a whole range of contractual provisions that, at least in India, seem to impact cybersecurity compliance. And a good example is privacy clauses that prevent breach reporting. For instance, if I have confidentiality clauses in my agreement that prevent me from doing breach reporting, that's a whole other kind of set of stakeholders that I need to manage in India. So just to sort of center the discussion again, there's three areas of interface. There's an omnibus interface with India CERT-In. There is and the Data Protection Board. There are sectoral regulators which are really active, especially around the financial services and telecom side. There are contractual relationships that you need to manage, especially because there are a whole range of confidentiality and data protection requirements that we see in contracts in India that might impact the way you think of your cybersecurity compliance. Now, there are a few other factors that I think, are second order factors that we usually think about and, we're having to kind of consider in India. For instance, what part of the value chain in the IT system are you, right? Are you merely a processor, right? Or are you someone who is doing a function that is what we refer to as an intermediary function here in India, which is basically basically any entity that's entitled to a safe harbor is treated somewhat slightly differently in India, and the considerations that you have in relation to cybersecurity compliance and reporting you think of slightly differently. Are you someone who's dealing with data breaches purely in relation to your employee data, as an example, right? So these kind of considerations also are layered over these kind of baseline considerations, especially in India, because and the reason that that's the case is because the 6-hour window is fairly tight, right? So a lot of companies in India are having to kind of layer these second order considerations to figure out what they really have to do within that 6-hour window. Right. So, so essentially, again, in India, we have a few stakeholders to manage. We have a lot of these second order considerations to manage as well. In terms of experience and, what we've seen, I've also seen kind of interfaces with law enforcement, and I'm talking about conventional law enforcement in the sense of the police, because especially a lot of cybersecurity incidents tend to go down the criminal route in India, at least on the ground, especially if there's larger sets of data involved, or there's kind of sensitivities involved in terms of what the confidential information involved in the data security breaches or in the cybersecurity compliances. We do see people going down the criminal route as well, although the efficacy of it is, sort of yet to be determined. So broadly, yes, that's exactly what's happening in India. And this is a quick summary. Back to you, Jennifer.
I was stuck on the point that you said it was a relatively tight timeline for 6 hours of reporting. I don't know how what can you report it after 6 hours? I'm not sure, but we will get into that shortly. Fran, I'm going to pass it over to you.
Thanks, Jennifer. So the U.S. is, quite a patchwork here, despite there being, widespread recognition that cyber threats are a significant risk. The US hasn't really enacted comprehensive litigation addressing cyber risk or information security at a comprehensive level. That said, that's not to say that there are no laws. There are just a lot of laws. So we have both at the federal and the state level a variety of laws that overlap and cover pieces of this. So over the years at the federal level, Congress has had some success in enacting affirmative information security requirements, cybersecurity requirements for sectors that are already more regulated by the federal government. So these include things like financial services, healthcare, telecommunications, energy, defense contractors. And these laws are things like the Gramm-Leach-Bliley Act, which was enacted in 1999 and focuses on cybersecurity and data protection for financial institutions. And then we have HIPAA, the Health Insurance Portability and Accountability Act, enacted in 1996, which focuses on those requirements for healthcare institutions and specifically set standards related to electronic healthcare information transactions. And then we have the CISA, the Cybersecurity Information Sharing Act, which was enacted more recently in 2015, and it focuses on encouraging the sharing of cybersecurity threat information between private entities and the government. And it's more focused on things like critical infrastructure and protection against large-scale cybersecurity threats. So these all kind of overlap and work together, along with a set of standards that have been put out by the National Institute of Standards and Technology, NIST, which is a non-regulatory government agency. So it's not a regulator, it's just a standard setter. And NIST has established a voluntary framework that sets forth cybersecurity standards and best practices that companies can use to kind of measure themselves. It's worth noting that, you know, this is one of the most important sources of general cybersecurity law in the US, but it's not a law. It is a framework. And under the framework, enterprises can kind of self-assess themselves to see how they're doing under 5 pieces of the standard: identification of cybersecurity risk, protection against cybersecurity risk, detection of cybersecurity risk, and then response and recovery. And outside of regulated sectors and the NIST framework, at the federal level, we also have several, regulators that have stepped in to kind of be the primary regulators for this space. So chief among those is probably the Federal Trade Commission, the FTC. Now, the FTC doesn't specifically have a mandate to regulate cybersecurity, but what they do have is general authority under their Federal Trade Commission Act to regulate unfair or deceptive trade practices. And based on that authority, the FTC has built a record on the protection of consumer information and privacy, and has really built up a technical background to look at data security measures when companies fail to protect data or fail to implement adequate safeguards. So they have kind of taken the role of the chief general federal regulator in that space. That's not to say other federal regulators haven't also taken a large role. I mentioned HIPAA earlier. The OCR there is, the primary regulator for financial healthcare institutions. And then on the more financial side, the SEC, the Securities Exchange Commission, has issued guidance and brought enforcement actions both for kind of financial related institutions that fall directly within its regulation and for publicly traded companies. And so among those, the SEC requires things like, most recently, disclosure by publicly traded companies within 4 business days of any materially significant cybersecurity incident. So all this to say, there is, a lot going on, a lot of moving pieces, and These federal regulations don't even all have the same triggers or thresholds. Some of them, like HIPAA for healthcare, are more focused on personal information. And then some of them, like the critical infrastructure or the publicly traded companies pieces, are more focused on just something that could have a significant impact. So on the federal side, there are a lot of standards to uphold. And then on the state side, in light of the kind of incomplete federal framework, states have also kind of taken a role in creating regulations regarding information security and data protection. Every state has a data breach reporting law. This started with California in 2002, and now there are, I think, 54. So it's all 50 states plus DC, Puerto Rico, Guam, and the Virgin Islands. And while they're similar, there are significant differences between them that I'm sure we'll get into a little bit later. And then in addition to these instant reporting requirements, which significantly, in contrast to GDPR and most of the rest of the world, focus on notifying individuals first, and sometimes notifying state regulators in addition to individuals, but the focus is really on individuals, so it's a public notice. And in addition to these, then there are also certain states that have set requirements for businesses to have things like a written information security program that maintains basic standards for protecting information and protecting against cyber risks. So it's a lot.
Well, I am so grateful to actually have to talk about Canada after that, because when it comes to complex frameworks, I mean, US makes Canada look like things are straightforward, which most people don't think that they are. Canada, like the US, has a layered privacy compliance regime. We've got federal law, which applies to the private sector generally, and then we have some provinces that have their own privacy framework. Where the provincial legislation applies, it will override the federal legislation, but only to the extent that it applies. So when you're handling a matter that affects all of Canada, you often have to engage with both the provincial laws where they apply, the federal law, and in certain circumstances, we also have some critical industries like the financial sector have their own compliance requirements and reporting bodies specific to that industry. So broadly, under federal law, we've got the Personal Information Protection and Electronic Documentation Act, PIPEDA, and we have general provisions that right now are not too onerous comparatively. For example, these obligations include having appropriate physical, organizational, and technological security safeguards to secure personal information. And where such security safeguards are breached, there's a mandatory reporting and notification structure to the Office of the Privacy Commissioner, with potential penalties that sit somewhere around summary conviction and fines up to $10,000, or indictable offenses and fines up to $100,000. However, we believe that all of that is about to change. We have Bill C-27, the Digital Charter Implementation Act, and it's currently under consideration, which, amongst other reforms, will increase those penalties to a more GDPR-like standard, including potential penalties for contravention with an indictable offense and fines not exceeding the greater of 25 million or 5% of revenue, or summary conviction and fine not exceeding 20 million and 4% of revenue, the greater of, by the way. The bill also has greater enforcement mechanisms to ensure that compliance. Canada also has another bill under consideration, Bill C-26, known as the Critical Cyber Systems Protection Act, or the CCSPA, which would introduce new cybersecurity requirements for federally regulated industries, including telecommunications, energy, transportation, and banking sectors. CCSPA would enforce that those organizations undertake a comprehensive review of their systems and their supply chains and create an offensive security posture. Some of the things that are currently under consideration under this bill would be establishing and implementing cybersecurity programs, fortification of platforms and architecture, establishing continuous monitoring, detection, and response capability, creating procedures and policies around cybersecurity, including incident response and data recovery, testing organizational controls, undertaking asset and vulnerability management, creating communication pathways to leverage cyber threat intelligence, and reporting cybersecurity incidents and complying with cybersecurity directions from the reporting bodies. The regulatory bodies, by the way. This bill also gives government new powers to review, receive, assess, and even intervene in cyber compliance and operational situations within those critical industries. Now, on the provincial level, there's privacy regulations in effect in Quebec, Alberta, and BC. There are additional health information acts. I'm not going to get into those too deeply, but with regards to personal information, everyone, those provinces I mentioned, except BC, have mandatory reporting and notification structures for breaches that meet the threshold. BC's requirements right now are voluntary but not mandatory. I'll get into a little bit about what we're doing on the provincial basis, including Quebec, which has enacted Law 25, the Act to modernize legislative provisions as regards the protection of personal information. That act comes into effect in stages. First stage was in September 22nd, 2022. Last stage was September 22nd, 2023. Next stage is 2024, September 22nd. As of September 2023, the Act mandates obligations on organizations transacting in Quebec to conduct privacy impact assessments under certain conditions, including when designing, developing information systems, or electronic service delivery involving the collection, use, communication, keeping, or destruction of personal information, and when transferring information outside of Quebec. Alberta, by the way, also has privacy impact assessments that are required when using information systems handling personal health information. I am going to stop there in the interest of time and jump us and move us straight into the discussion part of the conversation of this program. And start with, I think, a fairly easy one. What are the thresholds for reporting a cybersecurity incident in your jurisdiction? Fran, would you like to try that one?
Sure, I'm happy to kick us off there. So generally, I mentioned this a little bit in my last discussion. It varies. Generally, for most U.S. laws, both federal sector-specific laws and state laws, the threshold is that the incident must involve unauthorized access or acquisition of certain sensitive data categories. So in the US, this is often a more limited set than in the rest of the world. It is confined for data breach purposes, for cybersecurity incident purposes, to name plus things like a government identification number, a financial account number, sensitive health information, username and password, generally things that are considered highly sensitive or increase the risk of financial fraud or impersonation, those types of things. In addition to that, many of the states, not all of the states, there are about 10 or so, depending on how you count, that don't include this, but many of the states include a risk of harm analysis as part of that threshold. Again, this all varies by state. Some require acquisition according to the letter of the law. Some only say access. But generally, the state attorney generals, who are the primary regulators for these state data breach laws, most of them have taken the position that if you have evidence of unauthorized access, you can't really rule out unauthorized acquisition, even if you don't see some kind of massive exfiltration. So that's kind of the personal information side of things. Then again, we also have triggers, like I mentioned earlier, for some federal reporting that is broader than that. So things like material cybersecurity events, which publicly traded companies under the new SEC rules are required to disclose in public securities filings. Those don't trigger on personal information necessarily. It's just a cybersecurity event that could be material. And then there are also reporting obligations for events that could impact critical infrastructure. And so those may or may not involve personal information. I think that's an overview. There's obviously many more nuances, but I won't take all our time with those.
And that was the easy question.
Yes.
Stuart, how about in the UK?
Some similarities with what Franz described, some differences. It's taking sort of the critical national infrastructure type breaches that trigger on sort of availability and impact upon the services. There's quite specific triggering thresholds here that's probably too technical to go into here. Where the differences come out is more on the personal data side of things, and there we're probably many on the call know and have grown to love the GDPR's mechanisms for assessing a personal data breach and what that means, and that personal data breach can be quite easily triggered because of the way in which personal data is defined in the GDPR, because of the way in which personal data breach is defined in the GDPR. And if you are acting as a data processor, that's largely as far as you go. If you assess there has been a personal data breach, no matter how benign that might appear to you, your obligation is to notify the relevant data controllers. And so for when we act for sort of MSPs or services providers, those can be the most frustrating for our clients, because you have something that is really quite a minor in any objective view of the breach, but you still have that obligation to tell the data controller to make the assessment. And then if you're acting in the data controller's shoes, you then need to work out, well, if you've got a personal data breach, do we need to notify anybody about this? And there's two elements to that. There's one, do we need to notify the regulator, so the Data Protection Authority? And there is, under the regulation in the UK and the EU, a presumption that you will do so unless you can demonstrate that it's unlikely to be a risk to any individual. And if you can't sort of get around that presumption, then you should do the notification within 72 hours of becoming aware of the personal data breach. So that's where a lot of the initial quite hurrying around trying to work out whether there's a notification obligation kicks in that first 72-hour window of becoming aware of the personal data breach. So it's not becoming aware of the fact you've had a cyber attack, but once you become aware that there's a personal data implication to it. And then the second element to that is, do you need to notify any of the individuals impacted? And that is a much higher threshold, because you only need to do so if there is a high risk to those individuals. So there's sort of two different risk assessments to carry out, and you have more time in which to do that latter one. And that's where the data mining process will kick in to work out exactly what data has been affected and in what way, and therefore who needs to be told about it, if at all. I suspect I've possibly stolen Nino's thunder here, because that may be quite familiar with the position Austria in the EU.
Next time I'll ask Nino first. Nino, would you like to add anything to that?
So basically the same counts for Austria from the legal perspective. Just to add some flavor from my practical experience, especially in Austria, we usually tend to go for a notification, even if there are doubts if there might be any risk. So in case of any cybercrime issue, you usually have a risk, and you will usually also, from a perspective of the authority, have a high risk involved, because as soon as the attacker had access to the data, and especially if he had stolen the data and currently is in possession of that data, then you usually have a high risk implied, because you don't know, will it be published, will it be used, will it, even if it's just email addresses, maybe it will be used for further phishing attacks or something else. So in Austria, you usually tend to go to the authority and also notify the individuals. And then, as Stuart mentioned also before, we also have a comparable thresholds for network and information security and for the financial sector. So it's usually there if you have any kind of potential risk with your core business or core IT systems involved, then you also have to additionally notify those authorities.
And Jennifer, if I could come back in there, because actually there might be a point of difference to draw out with some of the approach in the UK, where a lot of the clients we advise, the assessment will be, yes, you can see the value in that over notification perhaps, but the risks of doing so might suggest that might not be the right approach, because either in the UK, the ICO has started to publish details of data breaches reported to it. So by making that notification, perhaps in circumstances where you may not come up to the threshold, you're putting the fact you've had a breach into the public domain. And then we have a litigation risk of individuals bringing litigation against the organisation that's leaked their data, and therefore quite often the approach is, well, if we have to tell them, of course we'll tell the individuals, but that scenario of telling them, even where we may not need to do so in the law, quite often there might be reasons not to do so.
So I'll just jump in for India here. I think Indian cybersecurity regulation is very much like FOMO regulation. I think the regulator is just really afraid of missing something out. So it's just overbroad in terms of what thresholds it prescribes. We have an annexure that pretty much in the law that pretty much lists out every known cyber incident to man, I think. And all of these are part of the 6-hour window. But what it does do in terms of thresholds is it creates a sort of distinction between incidents that have to be reported with what it refers to as full particulars and incidents that just need to be notified within the 6-hour window. So there's a subset of incidents which are data breaches, personal data breaches, incidents that involve large-scale cyber security infrastructure within the country, public infrastructure, and any cybersecurity incidents that have threats to life. So these 4 classes of incidents have to be reported with what they refer to as full particulars within the 6-hour window. Everything else just needs to be notified to the regulator within that time period, and the rest of the information can follow in due course. Now, that's the legal position, but the market has reacted somewhat differently to this, because I think this is mirroring something that Stuart was saying earlier, which is I think there is a risk-adjusted call to be taken between when you report and when you choose not to report. I think there is a whole range of considerations that people take in India. What is the public-facing impact of an incident? How many people have been impacted as a result of this? What is the discoverability risk? What is the litigation risk? And I think we have to do a kind of a composite analysis of all of these factors before we decide to go ahead and report within the 6-hour window. So again, no prescribed thresholds, but I think there are practical market standards. And there's, of course, a difference in the information to be provided within the 6-hour window.
It's interesting. You must be watching this develop in real time as everyone begins to adapt to the 6-hour window. In Canada, we have a very different system in this. We still move quickly, but the relative quickness in the 6 hours is a bit of a difference in standard. I mean, we're going to get into this. I want to understand what you can report in terms of your information after 6 hours. But in Canada, we deal with the real risk of significant harm as our risk analysis. And if there is a real risk of significant harm, then we've crossed our thresholds for both reporting and notification. Quebec has a minor difference to this. They've got a real risk of significant injury analysis. It's just but it materially not that different. And then within the financial institutions, we have OSFI. OSFI has a requirement for all material breaches to be reported within 24 hours. I'd like to move into something a little bit more meaty as a discussion topic. So I'm not going to call on people, but I would like you to jump in. In responding to a transnational cybersecurity incident, how do you balance deference to each jurisdiction on whether to report while maintaining unity on that messaging in what the substance of those reports say? And all of this while trying to stay within the reporting timelines. Getting international groups together within a 6-hour window must be a real challenge just by itself. So how do you handle such a thing?
Sorry, I'll just jump in first because I think the 6-hour window is picking up a lot of flack here, but
just with me.
Yeah, that's okay. So no, I think so wherever multinational, I mean, I've been part of at least assisted on a few multinational breaches. I think luckily for us, we've had factors in those circumstances where we could justify sort of going to the regulator and saying, look, there has been a breach or there has been an incident, but we're still gathering the particulars because it's incredibly complex for whatever reason, right? Or the breach has been of a nature where it hasn't been as severe as you would compare to the incidents that I mentioned to be reported within the full particular window. And so we've had the ability to take some more time on this, right? So yes, the 6-hour window exists, right? But Do people in the market really follow it to the T? Perhaps not, right? Because a lot of people just try and do only when there's like, I mean, and I've seen this happening only in like really serious data breaches where the 6-hour window is kind of really honored. And even there's sort of like, just a notification saying this is the information I have at the moment. You require XYZ from me, but this is the information I have at the moment, and I'm just telling you. But I am doing my diligence to tell you in due course what it's likely to be, right? In terms of deference, I think fortunately or unfortunately, the Indian regulator doesn't seem to believe that it needs to be treated differently from any other regulator, which is if you report in another jurisdiction, it's likely to want to be reported to as well here. But on the flip side, if there is no reporting in other jurisdictions, I think the Indian regulator does expect to be still reported if it meets the Indian regulator's requirements. But on a practical level, what we've seen is a lot of our clients, if they don't report in somewhere in either Europe or the States or in Canada or any of in pretty much in any of the advanced privacy jurisdictions, I think we don't see a reporting here in India as a practical matter, or at the very least, we see a very sort of scaled down, brief information kind of reporting here in India.
Stuart, I'm interested in hearing, I told you I'd ask Nino first, but for this particular one, I'm interested in hearing your thoughts on this. And particularly when it comes to the unification of messaging in transnational issues. How important is it for us to make sure that we're reporting the same things to the different regulatory bodies?
I think it's a really tricky one, because you're trying to coordinate the response and do all of the other things, as well as work out what the regulatory obligations are and do the necessary form filling in, whilst trying to make sure that the messaging is the same. And we've seen it happen in different ways, of those scenarios where different message is put into different jurisdictional reporting. Cracks can appear, and the regulators do talk. They do have conversations, and also in terms of timings as well, where you for whatever reason make the report earlier than others. Again, they talk, and we've seen, well, why have you reported in this jurisdiction quicker than here? And you have to explain that. We've also seen scenarios where we've been really good at giving the same message across the different jurisdictional regulators, and then because of the different approaches of each regulator to asking questions a different way, some are bothered by it, some are not bothered by it, some want to ask lots of detailed questions, that actually as you go through the response process, that's when the deviations start to appear in how to manage different jurisdictions. But I think it's a really fundamental thing to think about at the very beginning when advising on a cross-border breach, is to try to maintain that consistency as far as is possible to do so, recognizing that there are different triggers and thresholds and so on. But even within Europe, and Nino, please do jump in, but where you have broadly the same test and the same legal threshold, the different forms that you need to fill in, the different approaches. We often write a letter to the ICO. It's perfectly legitimate to call the ICO and report a breach by phone, but that's very different to other jurisdictions. We have a very prescriptive form, and you therefore do see those differences appearing.
Nina, did you want to add anything on that?
Yeah, absolutely on Stuart's side. So this is also what we see in practice, and this, of course, it needs to be aligned as the regulators talk, as they also, of course, want to see, is there something you might not inform a specific regulator about, but tell somebody else. And at the same time, maybe to add this here, it also needs to be streamlined. What is the data subject being informed of? Because this is also something that is shared. So if, for example, a data breach is mostly covering UK, and you also need to inform authorities in Germany and Austria, and also data subjects, and the information to the data subjects in UK has already started, this might already has been forwarded. This might already has been forwarded from the UK authority to the German one, or Austrian one. You really need to ensure that this information that is or has been exposed to the data subjects directly, that this is really in line with what you intend. That you don't have some cautious wording in your notification to the authority and be much more clearer to the data subject, because then you have a gap and then it's really tricky to stay in the driving seat. This is in the end what we try to teach the clients, because as you had mentioned, as soon as you're in the position that the authority starts questioning, you're not in the steering position anymore. So you might receive questions you may not be able to answer, or you don't want to answer at that point in time. So we usually try to hinder receiving questions and be as transparent and as clear as possible.
I'm going to jump in there, and thanks, Nino. I'm really glad you brought up the point of kind of data subject individual notifications, because that really is, the big difference in the United States. And I would say here, and this is, I'm going to talk pre the new SEC rules for public companies. So up until now, the focus really has been, and my advice to clients has always been, you want to be consistent, absolutely, but you also want to be giving messages that are appropriate to the audience. The way deadlines have worked here is that, most of the state data breach laws, which really drives the individual notifications in the US, have a 30 to 60-day timeline, not any of this 6-hour, 72-hour, nothing like that. But I think that's an important difference, because you have to be a lot more careful. These are public notifications. You have to be a lot more careful about what you're saying. You have to really know what you're talking about to not create some kind of public panic. Whereas going to a regulator in a shorter time frame, you can do things like what Stuart was describing with the ICO, where you call and say, we've had this incident, we're investigating, we'll give you more information. There's a lot more kind of flexibility to give those kind of high level, we don't really know what this is yet, but we think it's something, notifications to regulators, where it's a lot more difficult to give those to the public at large, especially when, it greatly increases things like litigation risk here in the US, which is always a major risk that our clients are thinking about. So prior to the new SEC rules for public companies, we've always, I've always advised clients to be consistent, go to regulators, tell regulators what you know when you know it, be consistent as that is evolving with regulators, but don't go to individuals. Obviously go to individuals within the regulated required timeframes, but you don't want to go out with noticed individuals before you really know what you're dealing with. And so trying to make sure that you fully understand the information before you go to individuals is really helpful in making sure you have that kind of consistent messaging. Now, the new SEC rules for public companies put a wrench in that, because they require public companies to, make a public SEC filing disclosure within 4 business days of determining there's a material cybersecurity incident. And the question for when that materiality determination occurs is an open question. But it's very possible that you could have an incident, you could know that it's going to be material to your business, but you may not know how many individuals might be impacted, if any individuals might be impacted. And companies under the new SEC rules are required to put out a message in their 8Ks publicly disclosing this. So I think that's going to be a real challenge for that. Already I'm seeing my clients grapple with this challenge, because once that's out in public disclosures, especially if they're a large consumer facing business, they're going to have consumers saying, well, what does this mean? Does this mean me? Does this mean my information? And that's really going to put a lot of pressure on kind of the 30 to 60-day clock for individual data subject notices that has traditionally been in place in the US.
It's kind of taking me back for a moment, because I dealt with many different breaches that have a really hard time with the forensics and even getting those names and addresses together within those windows. And I yeah, that's going to take away from a lot of people's sleep, I think, is really the way that I have to look at that. We only have 5 minutes left, so I'm putting my moderator hat back on and just letting the audience know if you do have questions, please put them in the Q&A. But I have plenty more questions, and we'll certainly use up the last 5 minutes if I can. I want to take everyone over a little bit to the law enforcement question and talk about sort of some of the positives and drawbacks, keeping in mind we have 5 minutes, of introducing law enforcement into the mix when it comes to incidents within your jurisdiction.
I'll kick off here. I'll just say the FBI in particular in the US has been very vocal about building roads to the private sector and saying, we're here to help you. We're not here to report you to regulators or other people. We're here to help you kind of track down, especially in ransomware type situations, track down bad actors, figure out what's going on, recover, help you figure out if it's possible to recover wire transfers, those types of things. That the FBI can be an incredibly helpful ally.
Nino?
I think it's so I was already looking into the Q&A from the audience. That's the reason why I'm struggling now. Because there was a rather interesting question on the paying ransom and if you're obliged to notify the law enforcement. Maybe to pick up that directly from the audience, in Austria you would not have to. You're not obliged to involve the law enforcement. You usually do so, but at the specific point in time, so that their support is not hindering you with your own forensics. And as regards ransom, there are many questions to be answered, but in the end, yes, in Austria there is a possibility to argue. Of course, it depends on your preventive measures. And it's connected to the business judgment rule. If you would be liable, it can be excused in the end, but it would be possible. I was struggling, but I was already into that question from the audience.
Should I pick up those two questions as well from a UK perspective? So law enforcement, I think it's similar to as Fran mentioned. Our UK law enforcement is getting much better at being of assistance. A few years ago, you would probably go through quite an artificial regime of notifying law enforcement to get effectively the crime reference number to include with your insurance report and so on. But now law enforcement is responding much quicker to reaching out to them. Whether or not they'll ultimately be able to do any better for the organisation than the IT forensics firm, quite possibly not, but yeah, they're definitely worth considering very carefully. The only sort of area where there is an obligation to notify law enforcement is if an organisation is thinking about paying a ransom, because they need to make certain disclosures for purposes of anti-money laundering obligations. Say for anti-money laundering obligations, the obvious thing that organisations need to check is make sure that they're not making any payment to a sanctioned or entity or terrorism group and so on. But subject to doing that very careful due diligence and forming a view on who you make a payment to, in the UK there's no overall prohibition on making a ransom payment. That said, the very strong guidance from pretty much anybody who matters, whether that's the ICO, National Cybersecurity Centre, law enforcement and government, is that very strong discouragement of paying ransoms. And last week, the UK government, jointly with Singapore, I think it was, announced a sort of general, we as a government will not be paying ransoms, and we encourage you strongly not to do so.
Thomas, we have 1 minute left.
Sorry, I'll just be quick. I think in India, you'd report to law enforcement. You're not required to, but you do it under two circumstances. One, if you know who the person is that caused the incident, you want to put some pressure on them. Two, if there are very large-scale breaches that are likely to be public, you want to do your diligence by reporting to law enforcement. So those are the two circumstances under which you would involve law enforcement in India. Generally, they're not very helpful, so that's the reason why people don't approach them. But in these two circumstances, that's what you do. Legality of paying ransom. There are, I think, very strong arguments for not paying ransom in India, especially because we have a closed foreign exchange regime in India. So we don't know where the ransom is actually being funneled to. So there is exposure to the company. So the risk-adjusted call there is to not do so. And yeah, I mean that's the position in India.
Very, very quickly, in Canada, we do have certain situations where we do have to call in law enforcement. We call in law enforcement primarily where calling in law enforcement would prevent further harm. One of the drawbacks of calling in law enforcement is that they take over the investigation and we lose the opportunity to keep privilege over the situation. That is an enormously simplified answer for a much more complex situation. But since we are over time, I want to thank the speakers for their time and energy in putting everything together. This has been a marvelous conversation. I want to thank iTech Law for all their hard work behind the scenes. Let the audience know that we are, please check the website and check the chat for future conferences and committee information. And I'll remind you that we do have a handout that we have put together that has been provided in the link. Thanks very much, everyone.
Thanks, Jennifer. Thanks, everybody.
Thank you.
Thanks.